The
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on Thursday, February 11th, 2021. I'd like to remind you that not only do we have this Short Circuit podcast, but also the Short Circuit newsletter, where we read the thousands of cases from the Federal Courts of Appeals so you don't have to. And every Friday, give you concise and fun-to-read summaries of the most intriguing decisions, including the two cases that my colleagues will shortly discuss today. Go to shortcircuit.org to sign up to receive the newsletter in your inbox every Friday, or go to the Volokh Conspiracy blog where it's later posted. Also, we are in the midst of Season 2 of our sister podcast, Bound by Oath, No Right Without a Remedy. Please subscribe on any podcast app or find it at shortcircuit.org. If you like that podcast, or even this one, please feel free to give us a 5-star rating on Apple Podcasts, which will help us find others who have not yet discovered the wonders of judicial engagement. Now, I coincidentally have with me today one of the producers of Bound by Oath, Anya Bidwell. And Anya and I have a special announcement to make in a moment. But first, let's introduce our other guest, IJ Singer attorney, who himself is very special, Bob McNamara. Bob, thanks for coming on today.
Thanks for having me, Anthony. Always a pleasure to be here.
Now, one thing you'll learn about on Bound by Oath Season 2 is the history of Section 1983, the famous civil rights law that today is used every day, especially in federal courts, but also in state courts, to hold government officials accountable for violating the Constitution. This year marks the 150th anniversary of the law, which was originally Section 1 of the Ku Klux Klan Act of 1871. It was signed into law by President Ulysses S. Grant on April 20th, 1871. In 2021, on April 20th, which this year is conveniently a Tuesday, you should mark a couple hours on your calendar as occupied. And why is that, Anya?
Because, Anthony, on April 20th, 2021, we will Zoom celebrate Section 1983's 150th birthday. We will have amazing guests attending the event, including folks who study the history of 1983, folks who think about doctrinal implications of Section 1983, and also folks who do the very hard work of litigating under Section 1983. And Bob McNamara just learned that he will be a part of this event too, and he will participate in that very panel that will discuss litigating under Section 1983. It is really a remarkable statute. And it really came into its own almost 100 years after it was enacted. The first 9 or so decades were a pretty rough going, let's just say. I believe actually Bob will discuss a case that's a good example of how Section 1983 allows individuals to fight for their constitutional rights. Right, Anthony?
That's right. And this is also, I should say, the first public announcement of this event. So if you're just listening to this right after the podcast has dropped, you're amongst a very special group of people, including Bob, who just found out he's going to be at this event. So mark your calendar, April 20th, 1871. More details will be forthcoming in the coming weeks. And when it is ready, if you don't see it otherwise, it will be available on the Center for Judicial Engagement's webpage. That's ij.org/CJE. So ij.org/CJE. If you're just listening to this for some reason on April 19th, 2021, which I know does happen. We get people listening to podcasts months after they're put out there. You still have time, and you can go to ij.org/CJE to check out this great event. Well,
it's going to be an outstanding event. I have been excited about it ever since 10 minutes ago when Anya simultaneously told me about and ordered me to participate in it.
And Bob follows orders very well, so you'll be sure not want to miss it for that reason too. Well, he's here to discuss a recent case from the Second Circuit, Williams versus Marianelli, that in addition to applying Section 1983, also brings up some particularly stark facts about our criminal justice system. Bob, I shamefully didn't know before I read this case that you often have to pay to be in prison. Tell us about that.
Yeah, so it's very common for there to be statutes ordering prisoners to reimburse the state for various services they have received, for the cost of their incarceration, frequently for the cost of their public defender services. And those statutes intersect in this case with Section 1983. And so what happened in this case is Rashad Williams, who is incarcerated in the state of Connecticut, tells the guards that he can't be put in a cell with a gang member. The opinion isn't clear as to exactly why, but we can all imagine there are reasons why gangs might become angry with other people, and Mr. Williams says he's one of those people. The gang is angry with him. And apparently, a corrections officer disregards this information and puts Mr. Williams in a cell with a gang member. And as per procedure, he puts them in both while they're handcuffed, and he sequentially uncuffs them as the prisoners stick their cuffs through the bars and then removes the handcuffs. And he removes the handcuffs by first uncuffing the gang member while Mr. Williams is still cuffed, at which point hijinks ensue. And it turns out Mr. Williams was correct about the emotions the gang felt for him. And he was beaten fairly severely. He was in a locked cell, so no one could get in to intervene for several minutes. And he was handcuffed, so he couldn't defend himself. And he sues. He says, among other things, you're not allowed to do that. You're not allowed to just deliberately expose me to beating when I'm defenseless, when you've made me defenseless. And he wins. He gets a money judgment against the officer who did that to him. And the state of Connecticut says, you know what? We don't want the officer to have to pay that judgment. We're just going to volunteer to pay that judgment. And you can't actually sue the state of Connecticut. The state of Connecticut has sovereign immunity. But not uncommonly, states come in and they say, we're going to pay that judgment. We're going to indemnify our employee. We don't want our employee to have to pay this. And so far, everything's fairly normal, except the state of Connecticut then says, and we're going to pay that judgment in the form of giving ourselves the money that Mr. Williams owes us for his incarceration. And substantially more than half of the award, the state of Connecticut pays to itself, deposits a little bit of money in his commissary account at the prison, and then announces, we're square. You were awarded 6 figures for your brutal beating. Most of that we're just taking for ourselves. You can have a little bit for yourself. And now the corrections officer is free and clear, and we'd like the court to say that the judgment is satisfied. And the Second Circuit says, well, not quite. It's perfectly fine for the state to have statutes that say Mr. Williams owes them money, and it can even be fine in certain circumstances to offset a judgment against the money that somebody already owes the government. But doing what Connecticut did here is undermining the purpose of Section 1983, which brings us to questions of federal preemption, America's favorite legal doctrine. And there's a thing called object preemption. And the idea is if the federal government's trying to do something, the state can't pass a statute that frustrates the government's purpose, that prevents the federal government from achieving what it wants to achieve. And the purpose of Section 1983 is to make individuals liable for violating the Constitution. And the Second Circuit points out, look, if you can do this, if the state of Connecticut can just say, anytime a prison guard gets a judgment against him, we're going to voluntarily pay the judgment, and also we're not going to pay the judgment, then prison guards are going to know that they can't be held liable under Section 1983, that as long as somebody's sentence is long enough, his incarceration bill is going to be high enough, and the state of Connecticut will satisfy any judgment by refusing to pay it. And that frustrates the purpose of Section 1983. That's not allowed. And so the court isn't ordering the state of Connecticut to do anything. The state of Connecticut retains its sovereign immunity, but the state of Connecticut isn't allowed to satisfy a 1983 judgment on behalf of a state employee by just sort of voluntarily adopting it and then declining to pay.
And Anya, when you collect on your judgments, generally, does the state take everything off the top?
Hopefully not. But, it's one of these cases, Anthony, where you read the introduction, right? And the court is very good at kind of like giving this introduction, which is long and very good at laying out the facts, gradually kind of unfolding the facts. And you think to yourself, please don't tell me you guys are going to actually rule in favor of the government, because it just seems so wrong. And then you get to the end of the introduction and they tell you that they actually agree with the district court and with the detainee, right? And that they totally agree that this is insane, right? It's almost more of just like a common sense judgment. Like, you can't tell me that, a state can voluntarily undertake to indemnify the officer and that use that essentially to deny the guy a remedy, right? Despite of what the district court found and despite of what the jury found, right? That's amazing. The jury basically said, you're totally right, Mr. Williams. What this guy did to you was horrible, and you deserve actual damages, and you deserve punitive damages. And then the state of Connecticut basically says, forget all about that, right? We're gonna use this weird loophole almost, right? And voluntarily indemnify the officer and make sure that you don't get any money. So it just, and I think the court kind of made it clear that this decision is narrow. It pretty much kind of applies on these facts because it just is not right what the state of Connecticut did here.
Yeah, and I think that's kind of the big takeaway is there's still plenty of stuff the state of Connecticut is free to do to Mr. Williams. I mean, it can sue him to recover these costs. It just can't extinguish a federal court judgment by invoking sort of its own Connecticut laws to stymie the federal court judgment. But if it wants to, I mean, as a matter of Connecticut law, Mr. Williams actually owes the state of Connecticut a lot of money, and the state of Connecticut, despite the fact that he owes them that money involuntarily, can use Connecticut law to go after him. They just can't kind of tromp into federal court and say your Section 1983 judgment doesn't mean anything because he owes us money in kind of this unrelated way.
Yeah, and defendants, they throw a whole bunch of arguments for why, right? For why Mr. Williams shouldn't prevail and that Connecticut was in the right? They talk about the 11th Amendment, for example, and the court says, well, the 11th Amendment has nothing to do with this. It's not like the guy is suing the state of Connecticut, right? It's the state of Connecticut that's voluntarily indemnifying the defendant and then denying a remedy. So the whole bunch of spaghetti that defendants throw at the wall to almost make it sound like Mr. Williams here is trying to get something from the state of Connecticut, right? And it's just all beside the point because the behavior is just so off. One of my favorite things is when defense actually is using qualified immunity as one of the arguments for why Section 1983 deterrence purpose is not without a limit, right? They're like, hey, but you can use qualified immunity here in 1983 cases, right? Generally speaking. So obviously 1983 is not what you say it is. But again, the court is not buying any of this and saying all of these arguments are just absolutely beside the point because what the state of Connecticut did here is very different from generally how these type of cases look like.
Those are always my favorite 11th Amendment arguments where the state kind of injects itself into a case and then announces the 11th Amendment apply. Like the state bursts through the wall like the Kool-Aid man and is like, you can't sue us. And I just imagine everyone in the courtroom being like, we didn't sue you. Where did you come from?
There are just so many layers of outrage on this case that it is hard actually to know where to start in talking about why the government's arguments were or Mr. Martinelli's arguments were wrong. And I think that's part of what the Second Circuit did in his holding is it just listed, you did this, you did this, you did this, and you did this. And basically when you have those 7 things, there's preemption. And the plaintiff is going to get his money. What I thought was just really particularly outrageous is the state has this guy under his custody. He sues somebody else who works for the state because of this silly thing we have called sovereign immunity and the 11th Amendment. And then he gets his money. And, when you win a judgment in court, as I'm sure some of our listeners who are attorneys or have just been in a lawsuit before have done, the defendant doesn't get to choose exactly how he pays you. You just say, okay, send the check to my lawyer, right? They could have just sent a check to his lawyer, put it in his own private bank account. That should be up to him. it shouldn't be up to the state of Connecticut, who wasn't even the defendant, to say, okay, we're going to give it to you this way, where we have complete custody over your funds. And then, by the way, you owe us this, this, and this, without going through the proper channels of then going and getting a judgment against him through the ordinary court system. And then if they do get a judgment, you can attach that to wherever he keeps his money in his bank account, which by then he could done whatever he's supposed to do with his bank account. I mean, perhaps they could put a lien on it, but the whole way the system is set up, you can tell, is for situations such as this. So if any money comes a prisoner's way, the state can become, say, first in line in attaching it. And beyond that, this idea, which I guess it says 34 states have this, where a prisoner has to pay for his incarceration, which I'm sure are almost never collected when a prisoner is released, but hangs over their head probably until they declare bankruptcy. We go on and on about how it's so hard to rehabilitate people. Well, that's got to be, almost top of the charts on how you're going to prevent someone from returning to a normal life on top of everything else.
No, it is. It's always useful, I think, in these cases to just imagine the same principles at play in a private dispute. Like if Anthony got a $20,000 judgment against me and I just announced, remember that time I mowed your lawn, Anthony? I did a great job. And that was a $20,000 lawn mowing job. And so we're square. And I'm just going to march into court and announce that we're square.
Luckily, Bob and I are fair and square in our prior dealings, except for this upcoming event he's going to be speaking at. So we can now move on to a happier subject, and that is misbehaving district court judges. So, Anya, tell us what's going on in the Fifth Circuit with Miller versus Sam Houston State University.
Yeah, so this is another one of those cases, just like the first one, where the Fifth Circuit, just like the Second Circuit in the previous case we discussed, is essentially issuing kind of like a common sense decision, right? Where it's, the law is certainly on their side, but more than anything else, you just look at the facts of the case and you basically think, oh, come on, right? You can't just behave that way. So that's why this case is also remarkable. It's about the Fifth Circuit calling out a judge, a district court judge, for behavior that any reasonable judge would not engage in. Like essentially helping one party over another and being pretty open about it. And here's a weird part, right? This same judge was already called out by the Fifth Circuit before, twice. So let me briefly describe the facts and you'll kind of get a flavor for this guy. The plaintiff, the tenure-track assistant professor, Audrey Miller, she was teaching philosophy in Sam Houston State University in Texas. When she applied for tenure, she was denied, and the university cited the lack of collegiality, right? That she's not agreeable, so therefore does not deserve tenure. She was also denied a raise. So she then filed complaints with the EEOC and the Texas Workforce Commission. And her argument was that she was discriminated against on the basis of sex. After her employment with the Sam Houston University ended, she applied to teach at this other university, University of Houston downtown. Looked like she was about to get the job because she was really qualified, but other people less qualified were hired instead of her. And she says that's because the two universities essentially talked to each other, and then the University of Houston was not interested in her anymore after talking to her previous employer. Long story short, Audrey Miller files 2 sexual discrimination suits in a federal district court in Houston, and her case lands with this judge whose behavior is at issue here, Judge Lynn Hughes. Apparently, Judge Hughes does not like what he calls tenure cases, right? So he says, I've seen so many of them. I know how this is going to end. So he immediately issues these orders limiting discovery and denying Miller her additional discovery requests. He also wanted to consolidate the 2 cases, but both plaintiff and defendant said that they don't want consolidation. So he basically, let's see if I can find it here. When Miller's lawyer, she says, we don't want consolidation, tells this lawyer, all right, fine, meaning that the case will not be consolidated. But he says, I will get credit for closing 2 cases when I crush you. That's a judge talking to a lawyer. When I crush you, how will that look on your record, right? So this is very strange behavior.
You don't find that in a standard scheduling order.
You don't find it in the standard scheduling order. And he also dismissed both university systems from the lawsuit, right? Both universities kind of are, they belong to 2 separate university systems, which were brought in as defendants. And he dismisses them without pretty much any discussions, right? And he also says about the systems, he says, that the systems, and that's again from the judge, don't do anything. They hire large staffs and make life difficult for actual institutions themselves. It's in their character to annoy their workers, right? And like that, systems are dismissed. Later, what's another interesting thing is that Judge Lynn allows the universities to depose Miller, the plaintiff, and denies Miller an opportunity to depose the universities. And here's when it gets really weird. The judge actually attends Miller's deposition, which takes place in his jury room, and he participates in this deposition, right? During the deposition, he actually lectures the plaintiff. A judge lecturing a plaintiff in a deposition on how she should not be discussing her feelings during the deposition and how she should really stay on point and answer questions directly and don't do side trips. Then in another hearing after that, he essentially encouraged universities to file a motion for summary judgment, right? He basically kind of, in a hearing, you can sense that he says, why don't you file a motion for summary judgment so we get it over with? And again, Miller did not get to do discovery other than a 2-hour deposition of one of the deans. And that was after the briefing was over. So this is just the court itself, when it's outlining these facts, can't believe what's happening here, except that they actually did see similar cases coming from this judge before. So the court essentially agrees that Miller, the plaintiff, that her case was handled improperly and that her case should be reassigned to a different judge. At first, basically, the court says that Judge Hughes should not have dismissed the systems as defendants by basically just saying that the systems don't do anything. The court then says another common sense thing, right? That the dismissal of the systems was premature because there is a complex fact-specific inquiry, what it means to be employer under Title VII, right? So it's not enough, again, for a judge just to say that systems don't do anything. You need to actually engage with the facts. Finally, the court actually says that the case should be reassigned, and it's kind of like a funny twist there when they say, by the way, reassignment will not be inefficient because discovery wasn't really taken, right? Judge Lynn Hughes didn't allow any discovery, so it's not like there's going to be any duplicative work. So we really don't think how this would be a big deal given the amount of effort that the judge put in the case if we were to assign it to a different judge. And I think at the end of the day, for the court, for the Fifth Circuit, what was really important is just to emphasize how judicial system really should be beyond reproach, right? That it should act in a manner that's impartial and appear also, not only act, but also appear impartial. And that this kind of behavior by a district court judge just undermines that goal, right? And one last thing I'll say is that Judge Hughes, he had several other cases that involved similar conduct. In one, actually, prosecutorial immunity case, where he ruled for a prosecutor, he actually told her, and I quote, "It was a lot simpler when you guys wore dark suits, white shirts, and navy ties. We didn't let girls do it in the old days," right? He's telling that to the prosecutor. And that's another case where the Fifth Circuit basically rebuffed this very judge. So there goes the story. And Judge Lynn Hughes no longer has jurisdiction over this case. And it is reassigned to somebody else. And Miss Miller is going to get another shot at this.
And I mean, in a certain sense, like, I think it's got to be very hard to be a long-serving district judge because from your perspective, like, I've seen 10,000 of these cases. I know exactly how this case is going to end, and I'm not going to sit here and let you guys spend a year wasting attorney time and wasting money doing discovery when I know the outcome of this case based on the other 9,999 I've seen. And like, the judge may well be right, but I think the point of the Fifth Circuit's opinion is that it's the judge's 10,000th case, but it's the plaintiff's first case. And the plaintiff is entitled to discover, like, there was this phone call between the two university systems. What was said in that phone call? And maybe it will lead to nothing. It will probably lead to nothing, if I'm being frank. But you're entitled to have that discovery. And I think it's really the refusal to allow any discovery without dismissing the case, but just forbidding any discovery because he knows how it's going to come out that sets the Fifth Circuit off here. Because usually, I mean, it's perfectly fine for, as litigators know, it's perfectly fine for federal judges to yell at you. I've been yelled at many times. Actually, usually I'm more concerned when judges are nice to me. Because, most judges are extremely courteous, but usually judges like even-handedly praise both sides. And they say, the briefing from both sides was very helpful. This was a very well-argued case. Thank you, counsel. But when the judge is nice to you personally, like actually the worst thing that can happen as a litigator is when the judge starts in with, your motion in limine was very thoughtful, Mr. McNamara, and I thought it was very well presented because like the only reason to be that nice to me is because you're about to deny my motion. And so I'm actually much more comfortable being yelled at sometimes than being praised. But, the yelling generally comes with, we're going to follow the rules of civil procedure and you're allowed to do what you're allowed to do under the rules. And if I'm grumpy about it, I'm also going to convey to you that I am grumpy about it. It's the combination of being grumpy with not letting you take any depositions at all is I think the thing that makes this really an outlier.
And usually when a district judge has seen a case 10,000 times before and kind of knows how it's going to end, they'll do things like push you into mediation or send you to the magistrate judge to try to have some kind of settlement conference, or even take it upon themselves for that kind of thing. Or I could even see in this case saying, okay, make sure you have that deposition about that one phone call early on, because then once you get that deposition out of the way, maybe the case goes away, maybe it's much easier to settle. But instead, I mean, this judge, if he wanted to get rid of this case, he shot himself in the foot by denying all discovery, including depositions about that. Whereas it could have been, if that had happened early on, he could have gotten rid of the thing if it turned out to not be anything.
Yeah, and so this judge, he has been on the bench for over 30 years, right? He is President Reagan's appointee. And he's seen a lot of these cases, right? And he knows how things generally end. But that doesn't mean that he can just go ahead and do away with cases in that manner. So it may be just, I'm thinking like, what happens? So generally speaking, judges, they are, appointed for good behavior, right? He's an Article 3 judge. He's not a magistrate. He's a district court judge. So if a judge is just on the bench for too long and have seen too many of these cases and is no longer interested in really engaging with a particular plaintiff's complaint, is there a way to hint to the judge that maybe it's time to go? Because you can't really fire them or anything like that.
Well, that does happen, as I'm sure many court watchers listening know. There does come a time for some judges where they really shouldn't be on the bench anymore, and yet they are. I know the story of a judge who's no longer with us, Judge Duff, Brian Duff, who is a judge at the Northern District of Illinois in Chicago. And I guess I've learned from my colleagues who practice in Chicago, went back when I practiced there after he had left the bench, that he was became more and more just erratic over the years. Weird things would happen in his courtroom. And I guess at one time there started to be whispers and maybe even something a little more official about impeaching him. Because, of course, at the end of the day, like with a president, that's how you can get rid of a judge is through impeachment. And this does happen from time to time, that judges get removed for, all kinds of things, drunkenness, taking bribes, what have you. So Judge Duff eventually came to an arrangement with the rest of the judges on the Northern District. They have a chief judge and they kind of run their own little show there, and they're overseen by the Seventh Circuit, where he would stay as a judge, but not really have very much going on. Kind of senior status on steroids. And I actually, when I was in law school and I was looking for a clerkship, Chicago is a place I was interested in clerking in. So I called around this is before Oscar. Back then, there was nothing online. Well, there was a little bit online, but not a lot. And so you would just call judges and say, okay, there's no postings, but are you hiring in the fall? And so I called a few chambers in the Northern District of Illinois, and I talked to a number of legal secretaries and clerks and got some info and said, thank you, when are you accepting applications? And then I called this one number, and this man answers. And I say, well, I'm calling about clerkships that you may have. And he goes, well, Anthony, this is the judge. I said, oh, Your Honor. Oh, very well. And I talked to him. He was very polite. And he said at one point, well, I don't have as much going on these days, but if you clerk for me, it would look very good on your resume. And I learned later that this was Judge Duff, and this was about the time that he kind of didn't have anything going on anymore. And maybe luckily for me, I wasn't. I did send him a letter, but I never got a phone call. And maybe he just didn't have any clerks at that point. When I started practicing in Chicago a couple years later, he was on the website, but there really wasn't anything there other than his biography. So eventually, I think he retired. If you are looking to litigate in the federal courts, of course, the overwhelming majority of district court judges are not like that, and never will be like that, and we are happy for that.
Yeah, I mean, cases like this are very, very rare. You don't really see, once you get a judge, right? And they do their best, you do your best, and you don't really see motions for reassignment being very successful at all. But in this case, kind of like in the previous decision that we discussed, it's just the facts of the case are such that the circuit court essentially feels like it has no other option but to reassign a case and provide the remedy that the plaintiff is asking, particularly in this very motion.
Yeah, and the Fifth Circuit didn't have a lot of case law really to go on, I noticed in this case, except for the one case involving the same judge from a couple of years ago.
Right, the Exxon case.
We'd like to thank Anya and Bob for coming on today and talking about judges and their various walks of life. And we'd like to thank you for listening. And until next time, we'd ask all of you to get engaged.